Hello everyone and welcome back to the channel. Hope you're all keeping well, and welcome to our latest episode of covering different areas of the England and Wales criminal litigation system. So this is a standalone episode on bad character, and we're basing this primarily for law students to get a better understanding on the area within the Blackstones syllabus 2025, but also an insight for the general public on how and what types of previous convictions or character or even incidents can be brought into a criminal case for a defendant. So today we're breaking down one of the most powerful and sometimes controversial types of evidence in criminal law, and that is bad character. And under Section 98 of the Criminal Justice Act 2003, bad character means evidence about a person's misconduct or evidence suggesting a disposition to behave badly, unless it relates directly to the offence charged or misconduct connected to it. And misconduct isn't just previous convictions, it can include past behaviour, repeated patterns, previous accusations, and anything showing a tendency to offend. The reason this topic is so important is simple. It can dramatically affect how a jury sees a defendant. If someone has a criminal past, it's tempting for a jury to assume they did it again. But the law puts strict limits on when this kind of evidence can be shown, because fairness must always come first. And we did touch upon this on the longer video during the criminal litigation series of videos, Chapter 5, Types of Criminal Evidence. I'll put a link in the comments below. And I think in that video we used an example of someone who's on trial for a sexual offence. And there's a distinction as to whether their previous criminal record comes into the trial, if it's admissible. And there's an example where someone had committed 7 or 8 rapes, and it was highly relevant to the current accusation of rape for which they were standing trial, compared to someone who's on trial for rape and years ago they had committed a shoplifting offence or low-level theft offence. So what's the distinction here? Bad character evidence cannot come in unless it fits one of the 7 gateways in Section 101, and if you are studying for the bar course, you will need to memorize these. And here they are. They are essential for the bar course. So A, all parties agree. If everyone is happy for it to come in, the court will usually allow it. B, evidence is required to explain something said or done. So this includes the defendant introducing their own character. C, important explanatory evidence. So sometimes the story doesn't make sense unless you know the defendant's background. D, propensity evidence. So it's an important matter in issue. This is a big one. Previous misconduct showing a tendency to offend. E, substantial probative value in a co-defendant's case, and this is used in battles between co-defendants. F, to correct a false impression. So if the defendant paints themselves as a saint, for instance, the prosecution can correct it if that is the case. And G, where the defendant has attacked another's character that opens themselves up, their own credibility may be challenged. And these gateways must be applied strictly. Bad character is powerful but dangerous, and the law keeps it on a short leash. So gateway D is the one that examiners and courts often focus on. So this is the propensity evidence, and it asks a straightforward question. Does the defendant's past behaviour help show that they're more likely to have committed the present offence? And try and think in the back of your mind the shoplifting and the sexual offence example. So under Section 103, the court looks at whether the offences of the same description, whether they fall in the same statutory category, or whether they are strikingly similar. For example, if someone has a history of a very specific fraud techniques, for instance, and the new offence uses the same unusual pattern, the court may treat that as highly probative. But caution is vital. Just because someone is or has offended in the past does not mean they did so again. So the court must balance probative value against unfair prejudice. And even if a gateway is satisfied, the judge must ask a second question: would admitting this evidence make the trial unfair? And under section 101, subsection 3, the court must exclude bad character evidence if it would have an adverse effect on the fairness of the proceedings. Under section 78 of PACE also, the judge has a general discretion to exclude unfair evidence, even if it fits a gateway. This is where protection against prejudice lives. We don't want juries convicting because someone looks the type, quote unquote, or because of an old mistake that has little relevance today. So while the prosecution may want to bring in a defendant's past, the court acts as a gatekeeper, ensuring fairness is always the overriding principle. So when there are multiple defendants, things get very interesting. So co-defendants sometimes try to use each other's past to strengthen their own defence. And under section 101, subsection 1, subsection E, this is allowed only if the evidence has substantial probative value, and the court will consider the risk of hostility or fabrication, whether the evidence generally helps the jury, and whether the attack is being used fairly. So for example, defendant A may argue that defendant B has a history of similar offending, but unless that history substantially helps the jury decide what happened in this case, the judge will keep it out. And this prevents trials devolving into personal attacks between the defendants. So that was just a very brief overview, and if you are studying for the course, then I do highly recommend you go to your textbooks and lecture notes and do some further reading, because it is quite a large and important area of criminal litigation and law. But to wrap up, here's the big picture. So bad character evidence can be extremely persuasive. It can show patterns, rebut excuses, or give context. But it can also be very dangerous, and it risks distracting the jury or encouraging them to convict based on reputation rather than evidence. And if you go back to the earlier videos that we made in the criminal litigation mini-series, then we highly stress that the role of the jury is to base their decisions solely on the evidence. And please find a link in the comments below. I've set out a separate video looking at the role of the jury and how someone got in trouble for discussing the case with other jurors after doing their own research. But that's why the 7 gateways, the propensity tests, and the exclusion powers exist, to make sure the courts strike the right balance between probative value and fairness. So hopefully you found this video insightful and helpful, very informative. As I said, disclaimer, it's just a brief insight, nowhere near enough detail if you are studying. But if you did have any questions, please do drop them in the comments below. Try to answer as many as I can. But thank you for watching, hope to see you on the next video, and it's bye-bye for now. Take care.